Okay, anybody who's watching, we're tuning in with Judge Mike. He stepped away for just a second, and he'll be right back.
Yes.
In the meantime, this is Jacqueline. I'm still here. I just had my camera turned off, but we are getting closer and closer to voting, to voting day. Remember that early voting starts October 24th, and Reverend King has listed all of the places where early voting is going to be taking place at, and we will be replaying that for you next week. All of those places. So here we are with the judge. Go ahead.
All right, very good. Welcome to the podcast, everybody, and I'm glad to be here. Thank you to Jacqueline and Electra for the kind hosting and offer to come speak to this podcast viewers and listeners. I am Judge Mike Engelhart. That's what it says on the shirt here. And it's so great to be with you. I actually live in Bel Air, Texas, so I'm inside the loop in Harris County. And let me tell you about myself, about what I'm running for, and why it's important, and all the different issues that I think are in the news lately and on TV commercials that I think your viewers would like to know some more about, and how they may relate to my campaign and my race. So my name is Mike Engelhart. I am a state district court judge in Harris County. And I'll tell you why I'm talking to a lot of you who are in Galveston and other places in just a minute. But I grew up in New Jersey. I was born in 1970. I'm 52 years old. And I went to college at the University of Michigan in Ann Arbor, go Blue. And then but having lived in New Jersey and in Ann Arbor, Michigan for the first 22 years of my life, I had plenty of winter and cold. And so every law school that I applied to was south of I-10. And so I ended up at the University of Houston Law Center, and from 92 to 95, graduated on time, and took the bar exam and passed and became a lawyer in 1995. When I was in law school, I met my wife, Eva, and her first year, a year after I started. And so that was 93. And we were married in January of 96, and we have two boys, Joey and Zachary, and they are 23 and 20 years old. My oldest, Joey, works in Manhattan, and my younger boy, Zachary, is a junior at Texas A&M University, Gig'em. And so I have been in Texas for about 30 years, and I've always said, since I got here, that Texas is the kind of place, and Houston and the area are the kind of place where it doesn't matter who you are, where you're from, or who your parents were. If you work hard, and then you can be successful. And so this place, this new home, new to me anyway, when I got here, embraced me. And I found opportunity and success. And in 2008, after practicing law for about 13 years, I decided to run for judge. And lo and behold, I defeated a 3-term incumbent Republican who was believe it or not, the cousin of Secretary of State James Baker. And so I became a judge and elected in 2008. And then I've been reelected 3 more times to 3 more 4-year terms. So I've been a judge now I'm on my 4th term as a state district court judge. And so that's about 14 years that I'm into this job. I am a civil district judge. What does that mean? Civil district judge is the kind of trial court judge like you see on TV, where you've got the judge up at the front at the bench. You've got the lawyers arguing their case at their counsel table or standing up in front of you. And you've got 12 jurors sitting in the jury box listening to the evidence. And in my kind of court, a civil court,
Recording in progress.
Harris County, we're specialized by court, whether it's civil or criminal or family or probate. or juvenile courts, then in my kind of court, it's the kind of court where people are suing each other over money. So it could be an injury case, a car accident, or a slip and fall, or medical malpractice. It could be a legal malpractice case. It could be a business dispute, breach of contract, or some real estate dispute. I just tried for 4 months a big construction dispute where the owner was dissatisfied with the contractor's performance on this gigantic refinery in Chambers County. And so any kind of civil dispute. In fact, back in the mid 80s, when I was still a teenager before I came to Texas, in my court, the 151st Civil District Court, there was a case called Texaco versus Pennzoil, which some of your viewers may have heard of, may be familiar with. Texaco versus Pennzoil, which at the time resulted in a $13 billion verdict, billion with a B, verdict, which was the largest civil verdict in the United States at the time, and that was in the court that I preside over now. So there's no upper limit to the amount of money that could be in controversy. So I regularly handle cases involving millions or tens or hundreds of millions of dollars. So it's a lot of responsibility, but I tried a lot of cases and handled a lot of appeals before I became a judge. So the learning curve was not too terribly hard for me or steep. And I do routinely get good marks from the bar, the members of the bar, the lawyers that practice in Harris County and surrounding areas in all of the polls that come out that the Houston Bar Association conducts. So now I'm 2 years into my fourth term as a judge, and I've decided that I want to run for a different position, a different judge position. And that is something called the Appellate Court, or the Court of Appeals, same thing. I'm running for the First Court of Appeals, Place 4. There are 2 courts of appeals in the Houston area. The First Court of Appeals, the one that I'm running for, and the 14th Court of Appeals. Why are there 2, and why are they have such numbers that are so far apart? Well, there are 14 courts of appeals around the state of Texas. They're in the big cities mostly. They're spread out. And what is a court of appeals? What does it do? The Court of Appeals is where, for example, if you're in my court, my trial court, and you went to trial and someone sued you, God forbid, and you ended up having a judgment against you for a lot of money or any amount of money or whatever it is, and you were dissatisfied, if you thought the jury got it wrong, that I got it wrong, then your remedy is to say, hey, you all got it wrong. I want a new trial. I want to go to the Court of Appeals, the higher court, the court that reviews my papers, that grades my papers. I want to go to that court, a brand new court that is the supervisory court, and ask that the jury's verdict and the judgment of the court be reversed, and that court rule in my favor, or at least send it back to the trial court with instructions for a new trial. So you get a do-over. That's basically what you're asking for from the Court of Appeals. In Texas, we have a 3-level court system. We have the trial court like mine. We have the Court of Appeals, the court that I'm running for. And then we have the Texas Supreme Court on the civil side. So if you were dissatisfied with what happened at the Court of Appeals level, then you could appeal further to the Texas Supreme Court. Or if your case was a criminal case, like a felony or a misdemeanor in one of our felony district courts in Harris County, and I will talk about other places as well, or a misdemeanor court, a county court at law, then you were convicted, God forbid, or a loved one was convicted of a crime and you were going to prison or jail, then you could appeal that conviction to the First or 14th Court of Appeals. But the Court of Appeals that I'm running for handles both civil and criminal, and also family law, like child custody and divorce cases, and, as I said, probate cases. So if there's a dispute about a will or a trust or something like that, then that could be the outcome of that trial court case could be appealed to the Court of Appeals, and we handle all of those different things. And you may say, well, Mike, you're a civil judge. And if you have to deal with criminal cases or probate cases or family law cases on the Court of Appeals, what will you do? Well, first of all, I've been studying all of those things my entire life as a judge and as a lawyer. And I've also made it a point during this campaign to visit with and talk to practitioners who specialize in those areas. And I'll give you an example. When I was a lawyer, I never handled any sort of oil and gas disputes. But as you can imagine, in Houston, Texas, that a judge would automatically be involved in lots and lots of disputes from the oil patch, right? About wellheads and about drilling rights and about patents and trademarks and injury cases involving oil and gas sites or offshore locations, maritime things like that. And you can be sure that I learned all those things. And if you ask any practitioner from in the Houston area that has practiced in front of me in one of those cases, they will tell you that I have learned that. And I can assure you that the ins and outs of oil and gas law and contracts relating to that and injury matters and all of that kind of stuff is vastly, vastly more complex than areas of family law or criminal law. While the stakes may be higher in a criminal matter or in a divorce or child custody matter, the complexity and the rules of procedure and the rules of evidence are almost identical. And I would be well equipped to handle those things at the Court of Appeals level without, again, much of a learning curve. Not to say that I won't study hard to get it right, because I do. And that's one of the things that I love about my job is I have the ability to get it right, and I generally do. A little bit more about me. Since I got elected in 2008, I am also a board certified attorney. I'm running against someone who is not a board certified attorney for this position. In 2016, I won an award from the Texas Association of Civil Trial and Appellate Specialists, TACTIS we call it, Texas Association of Civil Trial and Appellate Specialists, lawyers, a big lawyer group. I won the award for the Trial Judge of the Year from that group, and I was very proud of that. I also won an award from the University of Houston Law Center Alumni Association, Go Cougs, and that was for a Public Sector Achievement Award. And I do a lot of writing, and one of the things you do as an appellate judge is you do a lot of writing. And I think I said earlier, I handled a lot of appeals as a lawyer before I became a judge. I think like a lawyer who works in courts of appeals, because as a trial court judge, I only want to do things once. I don't want the case to come back to me a second time. I want to get it right the first time, because that's more efficient for the taxpayers of our area. I think like an appellate lawyer, and I wrote a paper, a legal article, not just an article, actually a research paper that I wrote, and I won an award from the College of the State Bar of Texas, which is the sort of the learning arm of the State Bar of Texas. And as you know, the State Bar of Texas is the organization that all lawyers in Texas belong to, and they have to belong to be a lawyer. And so the college is, again, the educational end of that, and I won an award for the best legal article from the College of the State Bar of Texas, I believe in 2017. It's called the Franklin Jones Award for the best legal article in the state that year. So I could do the work, I can, and I love being a judge, I really do. I want to talk about what areas are covered by the Court of Appeals, because people often ask, can I vote for it? And the answer is, in this area, yes. You may say, well, you're in Harris County and I'm not, so why am I listening to you? Good question. The answer is the Court of Appeals, unlike my current trial court, which is elected only from Harris County, the Court of Appeals that I'm running for is elected from a much bigger area. It's elected from the entirety, not parts of, but the entirety of a 10-county area, entirety of 10 counties surrounding Houston. And what are those? Well, I didn't know all the names of the counties before I started running. I've heard of the counties, but I didn't know exactly which ones were part of that Court of Appeals district. So I had to make a memory device to learn the names of the 10 counties. So the memory device, the mnemonic that I came up with is the first letters of each of the counties, and then made it into this sentence that I could remember. And that is this: always buy chocolate candy from good guys having weird Wednesdays. I'll say it again: always buy chocolate candy from good guys having weird Wednesdays. And so that's alphabetical of all the counties. So the counties, if you live in any of these counties, any part, any nook or cranny of any of these counties, I will be on your ballot a week from Monday when early voting starts on October 24th. So here are the counties. Ready? Austin County, which is Belleville and Sealy. Brazoria County, which is Pearland, as you know, and Angleton and Clute and Alvin and Meridiana and Iowa Colony, those areas. So that's Brazoria County. Chambers County, which is Anahuac and Mont Belvieu. Colorado County, which is Columbus, and I want to say Eagle Pass or something, I forget exactly, but Columbus is the county seat in Colorado County, out west of Houston, down I-10. If you ever go to Austin along I-10 and you turn on 71 to go up to Austin off of I-10, you just passed Columbus. That's Colorado County. Let's see, and then Fort Bend. So Austin, Brazoria, Chambers County, Colorado County, and Fort Bend County. So that's Richmond, Rosenberg, Sugar Land, Missouri City, Stafford, which is a very highly populated county, the second biggest county of the 10 that are in this district. And then you've got Galveston County, all of Galveston County, from the island all the way up to past the tollway, the entire League City, Texas City, Lamarck, all the parts of Galveston County. And then you've got Grimes County, which is Navasota and Anderson, which are sort of north and west of Houston. And then you've got Harris County, of course, the entirety of Harris County. And then two W's. You've got the Waller County, which is Hempstead and Waller and Prairie View. And then finally Washington County, which is Brenham. And so all 10 of those counties, if you live anywhere in those 10 counties and you go vote during early voting or on election day, or if you've got your mail ballot in front of you right now, you look, you'll see there's my name, Mike Engelhart, running for the First Court of Appeals, Place 4. I'm running against someone who was appointed by Governor Abbott last year, had never been elected to any position whatsoever, ever, at any time, not even dog catcher, and was just appointed last year, had never been a judge before last year. And as I said, I've been a judge for going on 14 years now. So those are the areas. Anywhere you live in those places, you can vote for me. Any nook or cranny of any of those counties: Austin, Brazoria, Chambers, Colorado, Fort Bend, Galveston, Grimes, Harris, Waller, and Washington counties in Texas. If you're not in one of those counties, then unfortunately, I will not be on your ballot at this time. But early voting is coming up a week from Monday, October 24th through November 4th. And election day is, of course, November 8th. But if you've got an absentee ballot, election day is today, right? So please fill out your ballot and look for my name, Judge Mike Engelhart, and vote down ballot. And please vote for me because, as I said, I believe I'm the most qualified, and I'd be grateful for your support. I want to talk about an issue that's been in the news a lot and on these TV commercials, and that is this issue of bail bonds, because I think there's a lot of questions about that. And the thing to keep in mind about that, first of all, is that we're only a few weeks away from an election. And so the truth has kind of taken a back seat. There really is not a crisis. This is something that has happened a couple of times. And the other side likes to make a lot of noise about it because it's really the only message they have. But it is not true that crime is up. In fact, crime is down. Crime is lower year after year. Murders are down. Other serious crimes are down. The catalytic converter crisis is down. Anything like that has really gone down and not up. But people are right to be concerned about the idea of a judge letting a repeat offender out on repeated bonds. But let's talk about what bail is and what bail reform means, and what the Eighth Amendment, the U.S. Constitution, says about bail and the right to bail. So, what is bail? If someone is accused of a crime and charged with a crime, they go before a magistrate, not even an elected judge, but a magistrate. And they are, and that magistrate will determine whether that person is eligible to receive a bail bond, and in almost every case they are, because the Eighth Amendment to the U.S. Constitution requires reasonable bail. The Eighth Amendment is not new; it's not something that judges make up. It is part of our original Constitution and the Bill of Rights. It's in the Bill of Rights, one of the first, which are, of course, the first 10 amendments to the Constitution. And the Eighth Amendment says that in almost every case, people are entitled to reasonable bail. What is bail for? Bail is not a punishment. Bail is not a get out of jail free card and go home and that's it. Bail is that you have to put down enough money and have someone guarantee that money, and you have to pay a premium for that bond, so that it's a promise that you will come back for trial when the court gets to your trial of your criminal charge. And so in misdemeanor cases, usually it's $5,000 or $10,000 or less, and you go to a bail bondsman and you say, I would need to get a bond, and they say, okay, well, how much is it for $10,000? Okay, well, the premium, at least historically, was 10% of that. It's like an insurance policy. You have to pay 10% of that premium of that bond face amount. So if it's $10,000, you pay $1,000 for it. They will post the bond, give you the paper to take to the court and say, or go to give the court the bond and say, I promise that if this person doesn't show up, we will forfeit this bond. We'll pay this $10,000, and then I will collect that from the person the criminal defendant. And so usually people show up for trial because they have a lot of skin in the game. Usually they have to mortgage their mom's house or something like that to get a bond, and or borrow from friends or relatives. And so they have to make sure that they come up with that money. So bail is a promise to come back. And a few years ago, there was a federal case in the Houston area with a Republican-appointed federal judge who said that our misdemeanors are low-level nonviolent crimes for the most part. Our misdemeanor bail system was unconstitutional. Why? Because if two people are accused of exactly the same crime, let's say it's a nonviolent crime, of possession of a small amount of drugs, which I'm not condoning, but it's not a violent crime, or spray painting their high school, when they get arrested. A rich kid can post the bond and go home and not sit in jail until their trial. A poor kid may very well have to sit in jail for months until their case is called to trial. And so the federal judge said that distinction, that money basis for getting out of jail or staying in jail, is unconstitutional. It is an equal protection violation. It's unconstitutional. And so as a result, in misdemeanor, low-level nonviolent cases, now courts are required to, the county courts of law that handle misdemeanor cases are required in most cases to give out personal recognizance or no cash bonds. And so the bond companies are suffering, such as it is. They used to be able to, they had their bread and butter was to get these $5,000 and $10,000 bonds over and over and over again every day. And that's how they made their money. But now that we're going to no cash bonds in most cases, and low-level nonviolent cases, they are losing money. So let's go over to the felony side and talk about that. So more violent, more dangerous criminals. Again, under the Eighth Amendment, like it or not, the Constitution requires that they be entitled to a bail of some amount, some reasonable amount in almost every case. And that's true if they're there for their first or second or sometimes third accused crime. And now, I would be very reluctant to let a violent criminal out on bond if I could possibly avoid it, if they're a danger to the community. And judges are required to sort of go through this checklist of are they a threat to the community? Are they a flight risk? Are they likely to leave town? How serious is the crime? And those, protecting the public. And in the very, very rare instance, all of those boxes are checked, and to such a degree that a person could be denied bond. But in 99% of cases, they are entitled to a reasonable bond because the Eighth Amendment, our Constitution, requires it. Some people talk about the First Amendment all day. Some people talk about the Second Amendment all day. And remember, under the Fifth Amendment, you are innocent until proven guilty in a court of law. So even if you're there for a second offense and you're already out on bond, you are not presumed guilty, you are presumed innocent under our Constitution, under the Fifth Amendment, that's another part of the Constitution, and the Eighth Amendment, which requires reasonable bail. But I can assure you that if I'm on the Court of Appeals and a district attorney appealed the decision about bail and came to me and said, hey, we think this bail is too low, you can be sure I would take that very seriously and determine whether I thought, as a Court of Appeals justice, whether that bond was too low and whether it should be raised, and always with an eye towards protecting the public. But I wanted you to be aware that there's not a crisis of people getting out on repeat bonds. It happens very occasionally. It happens because a judge has gone through the law and determined and tried to do their best to make a determination about what is correct under Texas law and federal law as it relates to the entitlement of the Eighth Amendment to reasonable bail. It has nothing to do with bail reform. Bail reform has to do with low-level, nonviolent misdemeanor cases where people get out on cash bonds. But here's the kicker. Here's the last point I'll make about that. And here's why we do face somewhat of a problem. It is bail bond companies. Remember I said they were losing money because of all these $5,000 and $10,000 bonds that went away because we went to a no cash bail system in many cases. So they're losing money. They're hemorrhaging money. They're going out of business. What do? Well, it used to be, remember I said they would charge 10% as the premium. 10% is the premium for a bond. So if a judge set a bond for a serious crime and a dangerous person at $1 million or $2 million, okay, what's 10% of that? $100,000 or $200,000. And so the bail bond company would say the premium for that bond, you want to get out of jail, the premium is $100,000, 10% of that $1 million bond. That's what it used to be. But now, because they're hemorrhaging money, these bail bond companies, which, by the way, are the ones that are running all these TV commercials you're seeing, supporting the Republicans, they are footing the bill for all those TV commercials. Why? Because they're going out of business, and they are now charging, instead of 10% premium, $100,000 or $200,000 for that $1 million or $2 million bond, they're charging 1 or 2%. They're charging $10,000 or $20,000, so that violent person has a much better chance of getting out of jail while awaiting trial. And when you're a violent, dangerous criminal and you're out of jail awaiting trial, the odds are higher that you might commit another crime. And so, believe it or not, all 5 members of the Harris County Commissioners Court, so there's 2 Republicans and 3 Democrats, all 5 members agreed just about 2 months ago on a resolution calling for bail bond companies to return to the traditional 10% of the premium. Now, they couldn't order it. They couldn't pass a law. That would have to come from Austin. But I believe there's a lot of folks that in Austin who receive contributions from bail bond companies. But I think it's important that they go back to that 10%, because when they're giving away those $1 million, $2 million bonds for dangerous folks for $10,000 or $20,000, they're much more likely to get out on bond and be a danger to the community. So I wanted your viewers to be aware, Jacqueline and Electra, that there are 2 sides to this story about that you're seeing on these TV commercials. It's not as simple as judges disregarding the law or being frivolous. It is not at that at all. They're doing their jobs. They're doing the jobs that we elected them to do. It is bail bond companies that are losing money, that are trying to find any source of income they can, and so they're giving away these bonds at a fire sale. And so that's what I have to say. I'm on your podcast today, and I'm happy to take any questions that you have.
I have been educated. What about you, Electra?
Yes.
I really didn't know the difference.
Me neither.
I mean, I knew, but I didn't know, and I also didn't know that the Court of Appeals, that the districts were so large. I mean, it's not like, a case here in, South Meadow. I live just south of you, and in Houston, and it's not like you're just handling Bel Air and South Meadow. You've got a very vast, broad area. And I always wondered, how come there's such a delay on court? How come it takes so long?
Yes.
Well, I think I figured it out. It's because, we got a lot of criminals, or no, we got a lot of people who have criminal issues that must be dealt with, or civil issues that must be dealt with. And, there's not a million Court of Appeals judges.
There's 18 in between the two courts. There's 9 on the First Court of Appeals, 9 on the 14th Court of Appeals.
Wow.
And you think about how many. So there's, I don't know, 80 or 90 trial courts in Harris County. There's probably another 80 or 90 amongst the other 9 counties. And so all of the appeals from all of those courts go to the First and 14th Court of Appeals. And one of the things that I have run on, one of the things that I've talked about, there's 24 civil district courts like mine in Harris County, 24. And I usually have the lowest or second lowest inventory of cases of any of those judges, which means that I'm working my cases, I do my job, I go to work every day, and I try to work through all of the issues and rule on cases and dispose of cases. My clearance rate is well over 100% every month. It's usually probably 120, 130%. And so one of the things that I want to bring to the Court of Appeals is that we work more quickly and issue opinions more quickly, because as your viewers know, the old expression, justice delayed is justice denied.
That's right. One of the things that I was excited about you talking about is the bail bonds, because in this area, I can tell you what's happening now. A lot of the officers are stopping these young teenagers for marijuana, and they may not even have a lot, not even an ounce or whatever, but they're putting them on these bail bonds, these bonds. And I really am one that really don't fully understand it, and I'm glad you're talking about it tonight. And one of the reasons is because a lot of parents have a great concern about it, because a lot of their kids are, trying to go into, like all of us, we've been teenagers and we've done things, and, we play perfect now, but we've done things.
Yeah.
And to hear you go in detail, and I know that you're helping this audience on bail bonds, as well as thank you for letting us know that crime is down, because they got everybody so scared. I'm telling you, really. All you hear about. Go ahead.
They're really trying to play to the animal part of our brains that fear response. But if people took the time to actually do a little bit of research, they would see there's plenty of sources that will show you that crime is actually down. It is true that it is scary to think about a criminal defendant who has already been accused of murder, then goes out on bail and commits another serious violent crime. That is a scary thought, but it is also rare as hen's teeth.
Yeah.
There are a couple of examples, and it's unfortunate, it's tragic when it happens, and we shouldn't let it happen. But it's just a few instances out of 10 million people in this area, and it is not something that is coming to your door at all anytime soon. And then for kids who are busted for marijuana, I certainly understand. I went to school in Ann Arbor, Michigan, and so I'm not a stranger to those issues. But I will tell you that you're talking about two different concepts. One is now, because of the ruling from the federal judge, most of those kids, if they're arrested, would get out on no cash bail, or personal recognizance bonds, or certainly very low dollar bonds. And why is that important? Why is it important that kids get out, or even just adults get out of jail and go before trial? Because if you're sitting in jail, what's going to happen? You are immediately going to lose your job, and if you've got a job, you're going to fail out of school or have to go try to get a GED or something. And if you've got kids, you could lose your family. right? Or you got, your marriage could fail, and we want people who are capable of being rehabilitated. In my view, anyway, we want those people to be able to lead productive lives,
Yes.
atone for their mistakes, and get on with their lives and be productive members of society. If we throw them away in jail for even just for months before trial,
Yes.
then that has consequences that could take years and years for them to overcome. And then on the back end of that, if they're no billed, right, if they're found not guilty, we want to make sure it's easy for them to have their records expunged, so that they are not showing up in employment applications or other applications. So again, it can be not if they're convicted. I mean, if they're convicted, you're convicted. But we're talking about pre-trial, or if they're found not guilty, or they're found innocent, or they're found, or the DA drops the case. We want to be able to seal those records and expunge those records so that those people can have productive lives and not be a drain on society.
Yes. Joe Biden.
Can I ask? Go ahead.
Joe Biden just
Go ahead, Alexa.
did something. He pardoned all of those with marijuana cases. But Abbott said that he's not going to do that in the state of Texas.
If you run a state like a church, then you are going to, or at least use that as an excuse to run a state, then you're going to have different outcomes than someone who wants actual good government, right? I mean, but what Biden did is he pardoned and is reviewing the classification of marijuana, but he pardoned people who are accused of federal marijuana charges. That's the only power he has as the president, is to pardon people accused of. But he called on governors to pardon people accused of state crimes. In the middle of an election where Governor Abbott is counting on, his conservative base to come to his rescue against Beto, then he's not going to, although I think it would be good politics, but he's not going to agree to pardon people who are accused of those crimes. And guess what? It would be a huge, huge cost savings and benefit to the state if we did that, because we don't have to police them. And all those people who were pardoned and had records expunged, et cetera, could then be much more productive members of society and pay taxes and contribute to our infrastructure. And so we can fix our roads and bridges and things like that. And we don't have to keep building jail after jail after jail at taxpayer expense.
I agree. And I'm just going to ask you, because I don't know anybody else to ask. It's been a few years ago, but I was robbed at gunpoint, and I'm disabled.
It must be very scary.
Yeah.
It was, but the scary part of it was then the plea bargains that these people got. I felt even more threatened by the fact that they weren't really being held responsible because somebody made a deal for something. Could you explain that? I don't understand plea bargaining. I don't understand how that works and why some people get to get a plea bargain and some people don't. I don't understand it. So
That's a really good question, and probably something that people wonder about all the time. And I am not the ultimate authority on that because, as you know, I'm a civil judge. But I do have a basic understanding of it, and I'd be happy to try to explain some of the things that go into it. What it really comes down to is practicality, and that doesn't seem fair or just, but it's really a question of practicality or reasonableness or rational thought. And what do I mean? So if someone's accused of a crime, it's not just simply accusing someone of a crime does not equate to prison.
Right.
Remember we said they're innocent until proven guilty.
Right.
And who's got the burden to prove that they are guilty beyond a reasonable doubt? Who's got that burden?
The jury. And
no, who's got the burden to prove it?
the attorneys.
No, the defendant, the one that accused you gotta be the one to prove that what you saying that this person done, they really done it.
Oh, yeah, okay.
So in other words, the district attorney, the state, the state's attorney, the district, which is we refer to in Texas as the district attorney, they are elected, and they are the person who their office has the duty, the burden under the Constitution, the Texas Constitution and the U.S. Constitution, to prove that the criminal defendant is guilty beyond a reasonable doubt. Now, that is a high burden. In a civil case like mine, the burden is the preponderance of the evidence, sort of a balancing of the scales. And if it tips a little bit one way, then the jury is permitted to find in favor of the person that proved that, just that slight difference. Another way of saying that is more likely than not. But beyond a reasonable doubt is like way up here. You've got to prove to the jury, if the jury's following instructions, you have to show the jury, for them to convict somebody, you have to show the jury that beyond all reasonable doubt, this person is guilty of this charged crime.
Okay.
Not easy. Not easy. I mean, if you've got an eyewitness and you've got pictures and you've got video and you've got a person who's an idiot and no alibi and all of that, then, and you've got forensics, right? You've got bullet fragments, you've got blood, you've got DNA, semen, whatever it is, then, then you've got a decent shot at proving someone's guilty beyond a reasonable doubt. But you don't always. And so we want to keep the public safe, but we know that in our legal system, we can't always prove that someone is guilty beyond a reasonable doubt, but we're pretty sure they did it, right? And they're pretty sure they did it too, right?
Yeah.
But so what do? You strike a deal. You say, look, you're not putting this out, you're not saying this out loud, but the idea is, the district attorney, I understand that it would be hard for me to prove this case beyond a reasonable doubt. Also, I've got 600 other defendants waiting to go to trial and sitting in jail or not. And so here's what I'm going to do. If I convict you, if I win my trial against you and prove that you're guilty beyond a reasonable doubt, the most you could serve is 99 years, all right, for a felony. But I will make you a deal. If you would agree to, 10 years or 20 years or something like that, then, and we'll go in front of the judge and we'll, ask the judge's blessing on that it's reasonable under the circumstances, because I think that, I'm pretty sure you did it, I don't have the ability to prove it beyond a reasonable doubt. I could take a swing at it, and you can take your chances, and you may get convicted. There's a very good chance you might get convicted, but I can't guarantee that you'll be convicted as the district attorney. And so I want you to go away to prison because I'm pretty sure you did it, and you should be punished. But I can't get the maximum, or I can't go with a straight face say that I know for sure that you're going to be convicted. So again, this is not all out loud, but this is the idea that's being expressed.
I think,
and so it's a matter of volume. You've got a whole lot of criminal defendants. You've got limited resources to the taxpayers and the district attorney to prove every case beyond a reasonable doubt. And so you kind of have to cut deals here and there.
I think I understand that now because I could not, I could identify the gun down to the strike marks, because I was so focused on it, but I did not.
My God, it's terrible.
I did not see their faces. Not really. I couldn't tell you if they were fat, thin, skinny, whatever. I didn't know. Now, one of them was caught on camera, so he didn't get a plea deal. But now I understand why the others did. So they asked me, can you tell me definitely that this? I said, no, I can't. But I can tell you minutely about the gun because I stared at it the whole time and I didn't look at their faces. So look at their faces, people, so that you can identify them. But one of them was caught on camera. So he didn't get a plea deal. Now I understand why he didn't get a plea deal and why the other two did. I got it.
And so, it's a matter of limited resources and you know what? I honestly think that's important as part of due process that in order for people to lose their liberty and go to prison, because if you were accused of a crime and you knew you didn't do it, you would want the district attorney's office to have a pretty high burden to prove that you did it,
Yes,
right?
yes, yes, yes.
Yeah,
Mhm.
that's
You
true.
wouldn't want it to be able to. You wouldn't want it to be frivolous or happen like with the
Right.
staff. You'd want to be able to defend yourself.
Right,
Mm-hmm.
right.
That's true.
Yeah, yeah.
And
And
that's,
and I understand that much better today than I have understood it at all. Period. I have been educated today. Thank you, Judge. Thank you very much.
That's
Yeah.
what I'm very glad for the opportunity. Thank you.
I have a
And-
question on
Go ahead.
here that someone is asking me through text, saying that why is it that the Republicans are able to be funded through a judicial system such as the bail bondsman? As they're going back to talking about, like when you were talking about the commercials. Yeah, it's the commercial.
So the U.S. Supreme Court made a decision several years ago in a case called Citizens United. Have you heard of that?
Oh yes, yes.
And essentially, what they did was they overturned a statute that prevented independent expenditures on campaigns. So someone could, without giving. So I'm running for office, right? And I raised money for my campaign. And Republicans do the same thing. They run for office and they raise money for their campaigns. But outside of that, there are things called PACs, right? You've heard of PACs.
Yes,
And
yes.
they can be independent. People can give money to a millionaire or a billionaire can give unlimited amounts of money to a PAC or to any sort of organization, really, and start running commercials to support a candidate.
Yes.
Got it.
Or just a group of candidates or an idea. And there's no limit on that. It used to be, but not anymore. And so because the Supreme Court, which is very conservative, said that money equals speech. Money is identical to speech.
Mm-hmm.
You're spending your money, or you're talking about, you're saying what you believe. I think there's some truth to that. That you ought to be able to put together an organization to advocate for a position that you believe in, but we can completely derail and undermine our political system and our democracy if there's no limit to what we can spend. Because at some point, $1 billion or $10 billion is not just speech; it is a tsunami. Completely overturning everything that we believe in terms of one person, one vote.
Okay.
And so it's these organizations, these bail bond companies have gotten together and they have decided that they want to go back to the old system of throwing away our kids in jail forever and locking up the key and locking away the key, or throwing away the key, and so they want to go back to judges that were there before. Do you remember? Did you read about in Harris County? We had in 2018 about 19 African American women judges won their races.
When
And,
Beto lost, they won. I remember that.
I've had the pleasure of working with them and getting to swear a number of them in and preside over their swearing-in ceremonies because I was already there, and that was been the honor of a lifetime where they call that black girl magic.
Okay.
But the idea was that look, these are people who are much more representative of our community and were elected to these positions, and now people basically, I mean, call it what you will, but people are unhappy with the notion that these particular women are in these positions of power and are doing what they're doing their damnedest to undermine them.
Yes.
That's terrible.
That
yeah,
is
I
horrible.
know. I remember that. That's horrible.
Mm-hmm.
And part of it is one of the big issues that Electra and I talk about here on this channel is women's rights. I have a master's degree in, I have a graduate certificate in women's studies, but I have a master's degree in other things. And I've studied women's rights and women's civil rights for years. And I was so excited when those women were elected.
Me too.
Because I thought, finally, maybe we're going to get some compassion.
Yes.
Maybe we're going to get some people who will listen. But people are trying to shut them up so hard, and it galls my, it really sets my teeth off. And I hope that in this next election, this election that's coming up, that we will realize you can't just vote once and it's done.
No, you got to keep going back.
The problems in the United States, we are a very young country still, very young, comparatively speaking. And yes, we have problems. There are things we're still learning, things we're still doing. But if we stop and give up and stop fighting for the people, because that is what our Constitution says, we the people, not we the businessmen. If we stop fighting for we the people, then it just, grass will grow over and we'll right back where we were.
Do you remember the old Mr. Popeil commercials? Remember, he would say, remember the oven? You would just set it and forget it. Democracy is the opposite. It is a contact sport. It is always ongoing. You always have to monitor it. You always have to fight these battles. You know, it's so frustrating for women who fought these battles in the 60s and 70s and got to climb the mountaintop.
Yes.
In 1973 with Roe versus Wade. And now we're fighting those same damn battles again. I can tell you that my opponent, who was appointed by Governor Abbott, will not be on that side of it. You know, another thing, Republicans like to talk about following the law. And one thing that is the law is that after the Obergefell decision from the Supreme Court in 2016, I believe, in June of 2016, that was the decision that legalized same-sex marriage in the entirety of the United States. And I remember being a judge that day, and I remember jostling with my fellow judges to be the first judge in Harris County to perform a same-sex marriage legally. We were fighting for that right, and I think I was the second judge and probably the second or third judge in the whole state to perform a legal same-sex marriage, and that was a watershed and a civil rights breakthrough. And I was really thankful to be a part of it. And but my opponent has not performed a single marriage since she's been in office as a judge. You know, we judges do a lot of weddings. She has not done one. And we were in the Houston Chronicle endorsement screening interview, the two of us together, and they asked her how come she has not performed any weddings, and I know the answer because all of the judges over there, all the Republican judges, don't do any weddings on the Court of Appeals, and that's because they don't want to do same-sex marriages. And so if they do one kind, they'll be accused of being discriminating against another kind. So she had no real answer as to why she didn't do it, but that is the law. That is the law, and if you're going to follow the law, then follow all of the laws.
Exactly.
And that's one of them. And I can't tell you how gratifying it's been to be able to perform weddings of all kinds, including same-sex marriages, for a couple very, committed couples, people who have been in loving relationships for decades. On that day, were finally able to legally marry. It wasn't like they just met that day. Like some heterosexual couples that I've married. These were people who are in long-standing relationships, loving relationships, and I was so glad to be part of their weddings to make it legal.
Yes.
And the issue that I want to always say, it's all about choice. They have the right to choose, and when you make a law or do something like refuse to marry people, you're trying to take away their right to choose, and they have the right to choose. And that is my same issue with the Dobbs decision, is you are taking away a person's right to choose. I'm not saying I agree with abortion or disagree with abortion, because that's not what the law is about. The law is about the right to choose. And there you go. Sorry. Okay.
That's okay.
There's my soapbox for the day.
No, we have 2 minutes left, and so only thing I'm going to say is I can't wait till Rovember. I call it Rovember. And I pray that many women go ahead, because you're going to have the
I was
last
just going to
word.
say, I've talked to women all over these 10 counties, and they are chomping at the bit to get out and vote. I know that a lot of your viewers are voting absentee, voting by mail right now, and so some people are already have that ability to cast their vote. And you saw what happened in Kansas in over the summer when they put on the ballot a referendum about abortion in Kansas, and you would have thought in a state as red as Kansas that would have been a no-brainer. They would have codified it in their Kansas Constitution that it is illegal under all circumstances, et cetera, et cetera. And lo and behold, women voted and people voted, and in a state as red as Kansas, they came back and basically 2-1 said no.
That's right.
We want to be able to have that choice. And if that's going to happen in Kansas, and that happened in a New York congressional race, congressional race in a special election, women voted in huge numbers. I think we're going to see the same thing around this 10-county area in this Court of Appeals race and a lot of local races. And there's going to be some surprises, and there's going to be some women will have had their opportunity to speak, and I think they'll speak loudly.
Oh yes,
So too.
all right.
And the men and reasonable men who support them too.
Yeah, we need the men to support us. I say that
That's
all
right.
the time. Men, we
That's
need
right.
y'all. We always stand with y'all. We need y'all to stand with us.
Stand with us. Yeah.
Well, we've run out of time. Thank you so much, Judge, for coming on. I always do this just to make sure that everybody has a closing word. So I'm done. Jackie, do you have anything to say?
The only thing I just went